Hello and welcome to this episode of Straight Talk with Tahir Noronha, a brilliant academic researcher, somebody who's been academically and otherwise involved on all issues concerning Goa's land, uh, the regional plan, the issues around 39A and 17.2. And I have invited him and very grateful that he consented to discuss a major decision taken by the Town and Country Planning Minister, Vishwajit Rane, where he has claimed that large portions of land which were earlier quote unquote settlement have been converted to again quote unquote non development zones. And Tahir will explain why I'm saying quote unquote NDZs during the course of the conversation. Now, apparently, 6,000 square meters have been brought back under the ambit of no development zone, and the TCP minister is claiming that this is his way of giving back to nature and stopping further plunder of Goa's land and forests. Uh, this, of course, the argument is that 39A of the TCP was not just about one-way conversion to settlement. It obviously included a two-way conversion back into NDZs. Now, obviously, this decision has, of course, interested many people. Many of them are saying that this is a great move by him to ensure that there's a give back process that also happens, and in some ways, it could lead to a justification that 39A is not so draconian. It works both ways, and the minister could be doing that and making this as an important handle for that justification. Uh, Tahir, I'll just straight away get into the meat of the discussion. Could you begin by explaining what this actually means and whether there is any category called non-development zones in the regional plan to start with?
So let's start with this idea of 39A. I think one of the biggest problems that we have raised time and time again is that 39A has no real guidelines, no real safeguards, there's no upper limit for what can be changed, and there's no real criteria for how the change can happen except for a very perfunctory procedural means by which it goes through the town planning board. It goes for objections for a very short time, and we have warned since the beginning that this can lead to really adverse consequences. And we've seen it time and time again. Shirida, people came on the street. Why? Because their entire hill, which was for the longest time, since time immemorial, a eco-sensitive one, non-developable zone, non-developable slope, which is, and I'll get to why I'm using that terminology, suddenly overnight got turned into a settlement zone by the town and country planning department. And this was despite them filing very detailed objections to the fact. And this is not just Sirida, this has happened to lakhs of square meters around the state of Goa, which have got finally converted from formerly eco-sensitive lands to settlement. Now, this has obviously gone to court, and there are a bunch of court cases. Most notable is a case filed by Goa Foundation, which challenges 39A in totality and says such an open ended law is not constitutional because it creates several violations of Article 14 and 21. But then, alongside it, now increasingly, there are a lot of other smaller cases brought in, one of which I am also party to, wherein some of us have filed objections, and different of us. I know I went in, I may be the second person who filed. I think Pilen Citizens Forum is the first. But now, last time our case was heard, there were 7 cases tagged with us. So I'm assuming a lot more people are also filing similar cases where we have filed objections to specific cases, and those specific cases have been overruled and converted to final.
Specific
Now,
cases against the implementation of 39A.
yes, against specific implementations in specific eco-sensitive areas that have been converted to settlement zones. Now, suddenly, in the duration of these these cases, Norma Alvarez, ma'am, actually made a point in court, and she said that, look, see how 39 is being used to convert eco-sensitive land to settlement land. And at that point of time, I was attending because obviously my case is tagged with the main case. And lovely that Bombay High Court has video conferencing. So I had joined it. And at that point of time, the government lawyer, some fancy guy from Bombay, he said, no. 39A can be used for both ways. And Norma had confronted him at that time saying, show me where you are doing anything in the opposite. You are claiming that it's to do flexible planning, to fill the gaps, in the words of their arguments in court. But you're actually only converting it one way. And it so happens that now suddenly we are getting statements from the minister that land is being converted both ways. We are putting some formerly eco-sensitive land in settlement, and we are allegedly, and we'll get to why I say allegedly, putting some lands which are developable into no development. Now,
yeah, I'll just to
break the monologue.
paraphrase what you've done. Yeah, no, but it was very interesting. All I'm essentially saying is, yeah. So you are getting to that. So just wanted to know whether everybody is curious as to why this grand quote unquote initiative of the TCP minister is creating a doubt, and the point being that somebody like you can actually state that, look, this is not really a doubt. The facts are that this is not really a conversion back to an NDZ. And taking into account this whole NDZ process, what really is NDZ?
Yeah. So let's actually look through some real life examples. Let's look at Chopde. There is the property survey 10/1A. I'll send you some screenshots of the property. But that land in Chopde is currently orchard. Large parts of it are natural cover. Large parts of it are no development slope.
They are already orchard. They are already orchard and no development.
In the regional plan, this land is orchard, which is an eco-sensitive 2, natural cover, eco-sensitive 2, no development slope. No development slope is defined under Section 17A of the Goa Town Planning Act. It was a law passed in 1997 by the Goa Vidhan Sabha, which says that all land that is steeper than 10% slope needs to be protected, and all land steeper than 25% can be no development. This is what we call a statutory definition. It cannot be of a no development slope. It cannot be overruled unless the Vidhan Sabha so meets and decides and debates that the act itself needs to be overwritten. Now, this portion of Chopade Hill has been marked, I'd say close to 40% of the parcel has been marked as an eco-sensitive 1, no development slope. Eco-sensitive 1 was a terminology adopted during Goa's regional planning, which implies a very highly eco-sensitive land, the conversion of which can lead to long-term effects on both the environment and the population.
One quick question. See, the Chopde land is roughly about 4,500 square meters, if I'm not wrong. Okay, roughly.
3 lakh. It's around 3 lakh 8,000 square meters in total.
Oh, that's 3 lakh 8,000. Okay, so what you're saying is, out of this 3 lakh 8,000,
out of this 3 lakh 8,000, approximately 3 to 4,000 square meters is settlement.
3 to 4,000 is already
currently settlement. Yes.
Okay.
The balance of the 3 lakhs, I'd say around little more than 1.2 lakhs is no development slope.
So in this case, as per Mr. Rane's announcement, you are saying this 3.8 lakhs will also be moved out of settlement into NDZ.
As per his announcement, he has saved a total of 22 lakh square meters of land in Perne Taluka, out of which 3 plus another 2.6, so close to 6 comes in Chopde alone. Okay, so 6 of the 22 he's claiming he has protected, whereas I'm saying that of the 6 was already protected. Chalo, 594 was already protected. 5,94,000 was already protected under not only the regional plan, but even earlier statutes like 17A, which defined the no development slope. Now a gazette has come proposing to change this land into no development zone. No development zone is very interesting because if you, I have my Town Planning Act and rules here. If you go through a Town Planning Act Chapter 2, there is no definition of no development zone. What we do find a definition of the no development zone in the regional plan. And over there, they only refer to a no development zone as defined by the CRZ notification. That means between the sea and 200 meters, which is no development as per coastal regulatory zone, that is what the regional plan recognizes as a no development zone. So this new terminology of no development zone has come from nowhere. It means nothing. It does not have a statutory definition like no development slope. It does not have a technical definition like no development slope does because it's a scientific measurement, but also like natural cover, which has a certain tree cover density, or orchard, which exists due to the revenue records. All of these are pre-existing eco-sensitive zones. Orchard less eco-sensitive, natural cover a little more, and no development slope highly eco-sensitive. Under the current laws, these lands cannot be developed. However, somehow or the other, this false assumption is being portrayed that these lands were formerly developable and now they have been saved by the benevolence of the minister.
Okay, I'll play devil's advocate just to keep the conversation a little more riveting. I'm saying, okay, we get it that the NDZ does not exist. One can say, okay, post facto they may ensure that the NDZ definition comes in and it all becomes legend. I'm just putting that aside for the time.
Mm-hmm.
But are you saying now there is out of say 22 lakhs in Perne, this Chobde alone, you were saying that out of these 6 lakhs, about 5.94 lakhs was already non-developable, right?
Mm-hmm.
Now, what about the counter argument saying, okay, do not accept that we are saving 22 lakhs or 6 lakhs in Chobde. Why don't you admit that we are at least saving that remaining portion? Even if it's a small portion, we are at least saving that. I mean, if what do you may say it's a facile argument, but what do you say to that?
So I don't have proof of this, but some of the villagers from Chopde were telling me that small portion, which is currently marked as settlement, is actually tenanted land, which could never be vested on. So, but leaving that aside, if we just look at the sum total aggregate, around 28 lakhs has been finally converted to settlement, and a further 70 lakhs is waiting in the wings for final notification, to which people have filed objections. They've been published for objections and the file is in process.
Right.
In comparison to that, per my calculations, which I very quickly did because I've not been looking at these no developments so carefully until now, I think we have around 4,000 in Chopde and another 1,500 somewhere else. And that's the amount of land that's currently marked as settlement that has been taken away. Most of he is touting a number of around 1.3 crore. That's 130 lakh square meters that has been taken out of development and preserved for future generation. Out of that, the biggest parcel is 65 lakhs. Exactly 50% of his figure comes from Wageri Hill in Sattari. The entire Wageri Hill falls within the buffer zone of the statutory Maade Wildlife Sanctuary. What does that mean? That is protected not by state law, that's protected by the national law, Forest Conservation Act. So it was no development under a national law. It could never have been built on. And the state government actually has no business interfering in the business of the national law, as many of us know it from the old Goa bungalow matter. The state government has no jurisdiction.
So, straight interpretation of what you're saying, that out of the 1.3 or 1.5 crores that the minister is claiming that he's giving back to into a no development zone area, 65 lakhs in Wageri Hill alone was in any way protected by a national law. And so there was no development happening there anyway. So the claim is reduced by half in terms of the area, right? Only by this argument itself.
Right there, yes.
Apart from the larger issue of you saying that A, there is no NDZ, and B, in many of the other areas in Chopde, there are only small portions of that area which are actually, convertible or or in settlement?
Less than 1%, less than
Yes.
1% of what he claims has actually
Mhm.
been in each
Right.
individual case. I mean,
Right.
another good example, he made an announcement that
Right.
Grand Island or South George Island in
Yes.
Mormugao is being protected. That is already a reserve forest under
Right.
the Goa Forest Act. Again, another separate state law that protects this. You cannot do anything there. It's
Which
marked
area is
as
this?
a forest in the regional plan,
Right.
and somehow or the other, this that is around almost 7 lakhs in Grand Island of land that was never developable. So if you start to look at it, it really becomes it really becomes funny because it's not really. I mean, in America they would call this a nothing burger. It's just, it's just
So
weird.
so this nothing burger, let's kind of load this burger with more facts. So number one, 65 lakhs in Vageri is already out of that 1.3 crores that he's claiming. Then
Hmm,
7 lakhs in Grand Island, which is already out of that
hmm,
that claim. In addition to that, there are other areas like Chobde and other places where the total amount under settlement is far less than the overall that has been claimed.
hmm.
That's what you're
So,
saying, no? Correct.
so I
Yeah.
have I have two more
Hmm.
interesting cases in Betalbati and Majorda, which are
Okay.
mostly paddy fields. Some
Right.
sand dunes are marked. Uh, some portions are settlement. I'd say maybe around 15-20,000. Now suddenly people will say, wait, no, he said total only 6,000. If you go through that gazette, it's very interesting. He has said proposed to change to no development zone, leaving area under settlement. So if
Where
there
is
was
this? Which
settlement, this
it's
is
in
in
Salsa.
Majorda
Majorda.
and
Okay.
Gansua Betalbati.
Hmm.
Uh, some total of around 250 and yeah, 440 square meters, 440,000 square meters
Okay.
proposed. Now, I'll tell you something else why I think these are particularly troublesome is because
Hmm.
unlike Vageri, Grand Island, even Chopade, where there is a definition under a separate law, paddy field as such really only gets its recognition from the regional plan. And what that means is that if something is removed, like these Marjota and Betalbati properties from the
Hmm.
paddy field designation, protections awarded to paddy field now no longer would probably apply, is particularly if you're changing it to something that is not defined. One of the most notable protections that's given to paddy fields in Goa is this protection under the Goa restriction of transfer of agricultural land, which
Hmm.
a law brought in August 2023, which
Hmm.
says that paddy fields can only be sold to individuals. You
Right.
cannot sell a paddy field to a company. Now, strange as it may seem, changing the Betalbati paddy field from paddy field to no development actually may just make it easier to buy the
Hmm.
field. A company who would have earlier not been able to purchase it may, if the cards align and if other reports fall together, because there are other
Hmm.
protections, including a report from the Agriculture
Hmm.
Department
Hmm.
under that
Hmm.
act. But it is one step closer to making the paddy fields, which were earlier not sellable, sellable. And this
But
reminds,
why would the company buy land in a no development zone? Suppose
because
no
the no
development is.
development zone does not have any, it was given under 39A. It can be taken away at any point of time. See, this is the biggest risk of 39A, is that it gives so much of power to town planning board that the town planning board may take and give, it's just that perfunctory 30-day notice that they have to give, and
Hmm.
then changing something from a no development zone to a development zone is a much smaller jump than changing something from a paddy field, which has a clearly identifiable connotation, to a
So what you're
settlement.
saying is that the area that he's saying he's giving back to NDZ is actually a paddy field which is protected anyway from being sold to anybody other than individuals. Now that it is under the quote unquote NDZ, a company may well buy that NDZ land for the time being and wait. And there's a risk of that being converted into any other category and opened up for development later.
And
That's what
and
you see.
we know how Goa government records work, right?
Hmm.
There's a fire, there's a rat, there's a
Hmm.
leakage. Suddenly, the old documents are lost, and nobody has any record that this land was at one point of time a paddy field. Tomorrow, JCBs move in and fill it in, and then they'll say this land, why it's barren? Why you marked it as no development? It is a mistake by the town planning minister. Let's change it now to settlement. Government is a continuous process. And so there is this risk also that I start to foresee, that lands that had protection only under the regional plans, such as paddy fields, are actually less safe when they are marked as no development.
Right. Right.
Let me tell you another story. Let's go back to Chopde, because Chopde is so interesting. The same property, 10/1A and 10/1E of Chopde, was actually in March 2023, just before 39A came. It was changed from this. It was proposed to be changed from these eco-sensitive zones to settlement. At that point of time, the very same, under a previous law called Section 17(2), which was found to be unconstitutional by the High Court and read down.
Yes.
And as a result of the High Court order, all the 17(2) conversions got reversed.
That's
But
right.
this exact same property came before the exact same government. And we're talking about how government is continuous process, just to back up my paddy field argument. This same government, same town planning department, same town planning secretary, same town planning minister, sit on the file and decide that this is fit to be changed from no development slope, natural cover to settlement. They
Right.
invalidated a technical measurement done by Survey of India, which said it's a very steep slope, and said, no, there's no slope here. Private engineer has given his report. There's no slope here. Make this it's fit to be a settlement land. And they went ahead and turned it into settlement under 17(2). Luckily, the High Court found that law itself unconstitutional because there was no public hearings. It got reversed back. Now, the same town planning department, in the same term of the same government, has somehow or the other found this land to be protectable. It really, really defies logic, because the facts on the ground, the land is still the same. I've gone and seen the site in December. I've gone and seen the site last March. It has not changed. There used to be a festival there called Echoes of the Earth, which was an environment festival.
That's right. Yes.
Land has not changed. It is still a very hilly kaju orchard and some steep portions just across from the Shioli Bridge. But the same government sits on the file in 2023 and says this land needs to be turned to
But the
settlement.
protagonists of the government would say that, okay, we made a mistake, then we are correcting it. What's your problem if you've realized that this is protective?
But it was already protectable to start. So you're doing nothing except for perhaps this is an election stunt, is my best guess at it. But it's the same properties of land also. There is another allegation I heard, but I don't have many proofs to back this up. However, I did read during the Perne zoning plan, there was an article that alleged that certain brokers were going around Perne and asking people to sell their lands. And if they were not selling, they were threatening to mark their lands as no development zones. And I have screenshotted that article many years ago and saved it in my email because I thought it was a very interesting claim to be made. And now I'm thinking that this, we don't know for sure, and I'm wondering if somebody has been pressured to sell and this has been done as a retribution to them. Ideally, those people should come forward. It would be very interesting to discuss and understand what their case is, because I think they would have a strong case to challenge it. But I do think that there is a slight suspicion in the back of my mind that there's been a little that perhaps a developer or a property owner who is not cooperating may be pressured to part with their land by threatening them that I'll make your land no developable. Who knows? Just because this is not defined, and because 39A gives the government so much power to take land from category A and put it in category B, there is a lot of risk that and a lot of power in the hands of the government to bully, to offer goodwill, to take away. All of these things can happen.
Two quick last questions. One, of course, if I could go into the NDZ definition itself and the fact that there is no NDZ, and you said that it's not part of the regional plan. Of course, it comes under a CRZ definition, not under under this. So we could just elaborate on that for a minute. Secondly, there is another very interesting example that that we were also discussing earlier. In Panjim, during the regional plan phase, there were areas that were defined which were not there in the definition before, and then the assembly had to meet to ensure that those definitions come in, so that they could justify the conversions. So, I mean, a similar situation arose earlier. So, could you just throw some light on that, and then we'll go to the last question.
So sometime in 2016, 2017, during the preparation of Panjim ODP, they made a new plan for Panjim, and in that new plan, they added two high-rise zones called special residential and special commercial. But they added those zones directly in the final plan, and they never came for debate. They never were defined the act or anything. So, Professor Edgar Ribeiro had filed a case in the High Court saying, you cannot do this. This is not how planning happens. And the government, before the case could be decided, went to the assembly and amended the Goa Building Construction Act to define these two land use zones.
Right,
so
right.
This is likely what could happen with the no development zone. Now the risk is that until a definition is made, the definition could be anything. I can say that this book is a green book, but I could also say that it's a red book. In the act, I could define it as a red book, and then everyone would call it a red book for the rest of their life, because because the only definition that matters in planning is the definition that lives in the act and rules, not anywhere else. I have another case. Give me 5 minutes. I want to tell you about this one because this is also very interesting. I'm just looking at my list.
Sure.
So in Madre, there are two properties on the Ashway slope. One of them is survey number 218 and one of them is survey number 201. They're both in this.
Okay.
There's a couple of properties, 206, 207, 208 in between them. Okay. But it's the same strip of orchard land, the exact same characteristics, everything the same. 201 has been changed from orchard with partly no development slope to settlement. 218 has been changed from orchard with partly no development slope to no development zone. So government is, and both have been finally done under 39A. So this government is really doing whatever it wants, two properties in the same area, not even, I would say, 200 meters between them on the same strip of orchard. One is now suddenly decided to be no development. One is suddenly decided to be settlement. The only difference between these two properties, on the Bunaksha, that is the land records, the occupant name is different.
So I get it. I mean, it's almost like saying one portion of your house becomes settlement, the other portion becomes an NDZ.
And it's only based on which brother or sister occupies that portion of the house.
Right. Final question before we sum up, Tahir. What about this argument that many of y'all are propagating, that since there is so much pressure on the government on 39A with these agitations and there's a people's movement, Siridao was a very big flashpoint where people went to the minister's house as well. Could this act of moving properties back into NDZ areas, could it be also an attempt at justifying that 39A is not such a big draconian act, but 39A is needed also for protection as much as it is for conversion to settlement?
Oh, undoubtedly. I think it aligns very well with the arguments made by the senior advocate appearing for the government in court as well, who makes this claim that many of us in planning theory and practice hear a lot, that planning needs to be flexible. we cannot rely on one regional plan or one development plan and every 10 years amend it. There has to be some way by which the changes of demography, changes in economy can be reflected to help people achieve their immediate needs and to cope with development. And so I think this matches very well with what the arguments both the government is giving in court and the minister is trying to do right now, by saying that, see, 39A is not only a conversion of eco-sensitive land to settlement, it is also a way by which we can protect Goa for future generations. Well, I think I've given enough facts today that none of the so-called protections till now have been truly to protect anything, but theoretically that argument does hold. However, my one suggestion would be that 39A needs to be, if it has to stay, I hear the need for flexible planning. However, there has to be guidelines and criteria. It cannot be this way. There have to be very, very strict criteria, such as what is the infrastructure capacity of the village, what is the current road carrying capacity, what's the demographic change, how do all of these factors mesh together, what is the will of the people, what are the Gram Sabha and the Gram Panchayat think of this conversion. Put all of these things together. You can do them in a flexible way. You can do them over 6 months time easily, and then do this. Further, also set very strict upper limits for the changes of lower designation eco-sensitive zones, such as orchards, perhaps cap it at 300 square meters, like a Munkar Act. And say, okay, fine, if there is need for housing in the village, and we can prove that there is need and there is infrastructure to support said need, we allow certain changes of orchard land limited to 300 square meters per applicant, only to individuals, not to companies. And do some flexible planning that way. Otherwise, and sure, definitely, for example, properties in Old Goa which are marked as settlement, even though they're protected under national acts, and TCP has given permission for construction in those properties in the past, only the courts have stopped. There are some errors. There are if the Chopra allegation is true, there is tenanted land that has mistakenly been marked as settlement. Those lands should go back into a different category of eco-sensitive, because they can't be developed on, and the settlement zoning is giving a wrong impression to the buyer who sees it on the regional plan, sees it as settlement, thinks they can do commercial activities with their money. So use 39A to truly meet the goals of flexible planning, right? Set very clear guidelines. All tenanted lands will be mapped, formally tenanted, whatever defined by the 1991 Act. Is tenanted, was tenanted is how the Act writes it. Map all those lands, use and set a guideline in 39A that these lands shall be given priority to be protected under 39A. But in the current form, without any guidelines, 39A is a disaster.
Right. On this note, Tahir, we'll have to end this here. Thank you for a very riveting discussion. Before we end, I'll just quickly sum up what Tahir said, and Tahir, you can add or subtract from it if you need to. Firstly, the claim that 1.5 crores, 3 to 5 crores that are being converted, that claim is fallacious, primarily because there are large portions of land that already could not be developed at all. So the fact that they've been brought back to NDZs is not correct, because they were NDZs in some form. The bottom line being that there could be no development. That's number one. Number two, in other areas away from this block that I was talking about, even in those areas, there would be portions, very, very, very small portions of the amount that is claimed that is actually, under the so-called development space. And that portion is very minimal. And even then, those portions also, in some cases, locals say that they are tenanted or otherwise not developable. So the larger argument that one is giving back so much to non-development, that larger argument itself at the very charitable level needs to be brought down by almost 70 to 80%.
But 99%.
Okay, 99%. Okay. Okay.
Per my
So that
calculation, less than 1% of the land that is said to be brought is currently settlement.
correct.
I think it's 0.02. So you can actually go 99.98%.
Fair enough. And more importantly, apart from all this, the very definition of NDZ is absent because there is no definition. So NDZ has to be defined because there are no development slopes, there are no development zones defined in the regional plan. That definition is very important so that the extent and the specifics of that is totally defined. Otherwise, you leave it to the imagination of the converter, either way. So that is the second point. And third point that I made right at the end is that flexible planning is important, but do it according to a particular structure so that it benefits, and it shouldn't be in the form of a trial balloon or an attempt to justify 39A, but do it structurally so that the real ends are actually met. On this note,
Structurally, with upper limits and with a goal of sustainable development in mind, to correct true errors that have been committed by some inadvertent way or the other.
absolutely. So, Tahir, thank you very much for this discussion. This will really, put the whole thing in perspective and help people who want to research further to do so, look into these properties, and come up with facts. As always, if there is anything that the government has to say and over and above this and justify itself, we are more than welcome to hear it so that we can analyze and scrutinize that as well. Thank you so much, Tahir. Signing off now, and thank you again.